we are going to deal with offences against the state under Indian Penal Code. A stable and secure government can maintain peace and order in a society, and peace and tranquility. The IPC declares that as done in protection of sovereignty of India against this is very serious offence, and which can even deal to death penalty. Offences of wagering war against the state is one of the greatest offence, and the reason being that in such an offence the object is to strike directly at the government's authority and government's power. The term war embraces every description of war, whether it is ideological or insurrection or invasion. Such offences are more serious than even murder, so the offences are to be dealt very strictly. So we will see the offence of waging war under section 121 of the Indian Penal Code has to be a very important area. That is, the section provides that whosoever wages war against the government of India or attempts to wage a war against government of India, or abets the waging of war, even doing, attempting or committing any offence against the waging of war against the government, shall be punished with death or imprisonment for life or with fine. So whosoever, whether it's a person or a group or an individual, whoever may be involved, it is not material that such persons has to be dealt very seriously. And in the Parliament attack case of the year 2005, it has been held that whoever, whether it is a citizen or a non-citizen or a person of the country or a person outside, they are all equally liable for the same kind of offence. Though the offence against the state is very important in such situations. Similarly, in the case of Mumbai attack, waging war against state is happened in section 121, where there was an attack by the Pakistani forces on Taj Hotel in Mumbai. Even that has been mentioned that whether the person is in India or outside India, such persons are liable to be punished heavily, and they are to be abandoned as such as an enemy to the country, and their punishment can go even up to the death sentence. So the Supreme Court has expanded the expression that it includes every person, and every attempt, even an attempt or even supporting and abetting of a war, will amount to waging of war against the government. And even there is need for proof. When such a proof is there that an activity is done with an intent to create any objection in the country and a law and order situation in the country, then such persons will be punished under section 121 of the Indian Penal Code. Then 122 provides that any person who is collecting any arms or any ammunition with the intention of waging war is also punished. Not only waging war or attempting or abetting, even collecting or bringing or trying to bring any arm for the purpose of such a act against the public is punished. And even concealing to a wage war is itself a kind of punishment that has to be given by the Indian Penal Code. And so it is a very important area. And based on the increase of the activities of terrorism that is happening in India, we have to say that the Unlawful Activities Prevention Act 1967, that is we call as UPA Act, has been amended in the year 2019. And 2019 provided that even an individual can be named as a terrorist. Previously, terrorist was only a person belonging to terrorist group only, not an individual. So now, after the 2019 amendment, it has been found that even an individual who is involved in any terrorist activity shall be liable to be attracted under the Terrorism Act. And section 15 of this UAPA Act provides that whoever does any act with the intent of threaten to life or likely to threaten the unity, integrity and security, including economic security or sovereignty of India, shall be liable for the death of or loss of damage or disruption of any supplies or services or any damage to the monetary stability of India, or any other destruction of any other property, or use of any criminal force, or kidnapping or abduction, they shall be taken as a terrorist. And the punishment for the terrorist activity is that if such an act has resulted in the death of any person, then he shall be punishable with the death or imprisonment for life, and shall be liable to fine also. So, in any other case, the punishment of imprisonment for the life shall be not less than 5 years, but which may extend to imprisonment for life usually. So, not only the act of terrorism, but also even raising funds for the terrorist act is punishable under section 17 of the UAPE Act. Whosoever in India or in a foreign country, directly or indirectly, raises any money or funds for the legitimate or illegitimate source for any person who is attempting to or provide any funds for the purpose of this kind of terrorist activity, they shall be punished for participating, raising funds or collecting funds in the same manner as if they have done the act of terrorism. There is also another punishment under section 18 for the purpose of conspiracy for involving in such kind of activity for terrorism. So the UAPA provides very strict ground, and it is not a bailable offence. Any person arrested under UAPA Act can be kept without trial for a period of 1 year, and he will be subject to trial only subsequently. And the Act very clearly provides that not only organizations and also the people who are, even an individual can be involved into this act, and also any person recruiting any person for the terrorist activity, or even abetting or doing some collecting of the fund, or organizing terrorist camps, and even punishment of for threatening of any of the acts. All these are deemed to be the offences under UAPA, and any offences against the state is taken seriously by the Supreme Court and other countries. Other provisions, and there are also provisions for sedition and all other activities that is being done, and whoever may be committing it, and such offences shall be strictly dealt with as offences against the public in India. Thank you.